Hey there, Dennis here with Safe House Property Management. Security deposits are one of the most litigated areas of landlord-tenant law in Wisconsin, and most of the time, landlords lose. Not because they did something malicious, but because they didn't know the rules. Today, we're breaking it all down. Now, I'm not an attorney, and nothing in this video should be considered legal advice. But we do work closely with attorneys who specialize in Wisconsin landlord-tenant law, and who know firsthand how these cases are actually being settled in the courtroom. What you're about to hear is drawn from that real-world experience. Everything starts with Wisconsin Administrative Code, ATCP 134. That's the rulebook for landlord-tenant relationships in this state. It specifically governs what you can and can't deduct from a security deposit, and courts take it very seriously. So what can you legally deduct? ATCP 134 gives landlords a defined list. Damage, waste, or neglect to the unit, unpaid rent, unpaid utilities the tenant owes, and charges outlined in a Nonstandard Rental Provisions document. That's it. If it's not in one of those categories, you don't get to keep it. Let's talk about that last one. Nonstandard Rental Provisions, or NSRPs. NSRPs are what allow you to charge for things beyond the basics, like late fees, NSFs, cleaning, or rekeying, but only if they're done correctly. They must be in a separate written document, not buried in the lease, and clearly identified to the tenant with a signature or initials. And even then, you're not automatically protected. Courts will still look at whether the charge is reasonable and tied to actual cost. We've seen violation fees thrown out entirely and flat rate charges rejected because there was no proof of what it actually cost. Verbal agreements don't count. Buried lease language doesn't count. It has to be clear, separate, and signed. But here's what most landlords don't know, and where they get burned. Even with a signed NSRP, Wisconsin courts heavily scrutinize every security deposit deduction. A judge can still reject it. Just because you think you should doesn't mean you can. And just because it's written doesn't mean you'll win. One of the biggest battlegrounds is normal wear and tear. You cannot deduct for walls that faded over years. You cannot deduct for carpet worn from regular foot traffic. Worn carpet after 5 years? Wear and tear. Carpet with cigarette burns and pet stains? Damage. Scuffs on a wall from furniture? Wear and tear. Holes punched through drywall? Damage. The tenant is not responsible for the natural aging of your property. Courts also apply a useful life standard. Carpet typically has a useful life of 8 years. Interior paint, 3. Appliances, 10. If a tenant lived there 3 years and your carpet was already 6 years old, a judge may say that carpet had minimal remaining value. Your deduction gets reduced accordingly. This is exactly why move-in documentation matters so much. Documentation is your only real defense. Date-stamped photos before move-in. A completed check-in form, yours and the tenant's. Photos after move-out. A completed checkout form, before and after, in writing, every time. Without it, you're walking into court with nothing but your word. The clock starts when the tenancy ends, meaning the lease is over and the landlord knows the tenant has moved out. Wisconsin law requires you to return the deposit or provide an itemized written statement of deductions within 21 days. Miss that deadline, and if challenged, you forfeit your deductions and may owe double damages and attorney's fees. Calendar it every single time. And here's what getting it wrong actually costs. Wrongfully withhold a security deposit in Wisconsin. The tenant can sue you for double damages. Keep $800 you shouldn't have. You could owe $1,600, plus attorney fees, plus court costs. A small mistake becomes a very expensive lesson. Security deposit law is detailed, strict, and easy to get wrong without the right systems in place. At Safe House, we handle every step: documentation, deductions, timelines, communications, so you never have to wonder if you're exposed. Visit us at safehousepropmgmt.com or give us a call at 414-775-0207. We'll see you on the next one.